You're riding shotgun. Your friend gets pulled over for a broken taillight. Nothing serious, a 2-minute stop. The officer gets the driver's license, walks back to his patrol car. Then something unexpected happens. He comes back. He walks straight to your window and says, "I need to see your ID too." You didn't do anything, you're not driving, you're not suspected of anything. But that officer is standing there, badge, uniform, hand extended, and every instinct is screaming, "Just hand it over." And that is exactly the moment this video is about, because what you say in the next 30 seconds determines whether this stop ends quickly or whether you hand law enforcement the leverage they need to extend that stop, search your belongings, and change your life. This is educational content to help you understand your rights. For specific legal guidance, consult a licensed attorney in your jurisdiction. I've analyzed hundreds of traffic stop body cam recordings from passenger encounters and studied every controlling Supreme Court case on this issue. I've identified 5 exact phrases backed by case law that protect passengers who have done nothing wrong. Most people have never heard these phrases. After today, you will. Number 5 might surprise you, but number 3 is the one that stops officers cold, because it forces them to answer a legal question most cannot answer lawfully on camera. Stay calm, stay polite, but stay firm. Here are the 5 phrases every passenger needs to know. Phrase number 1, "I'm invoking my Fifth Amendment right to remain silent. I won't be answering any questions." Here's the mistake nearly every passenger makes. The officer asks who you are and you start explaining yourself. "I'm just a passenger. I don't even know why we got pulled over." Every word is now on body cam. Every word is potential evidence. Picture this. You're in the passenger seat. The officer leans toward your window. "I just need to confirm who's in the vehicle. Can I get your name?" It feels like a requirement. It sounds like a requirement. So you talk. "Sure, I live on Maple Street. I work at the clinic downtown." Stop, right there. You just gave the officer your name, your neighborhood, your employer, and a clear willingness to engage. Body cam captured every word. Why do people do this? They think cooperation means conversation. They believe explaining their innocence will make the officer leave them alone faster. The legal reality is the opposite. In Salinas versus Texas, decided in 2013, the Supreme Court ruled 5-4 that simply staying quiet is not enough to invoke your Fifth Amendment right. Genoveva Salinas fell silent during police questioning. Prosecutors were later allowed to use that silence as evidence of guilt at his murder trial, because Salinas never explicitly invoked the privilege. The court held the Fifth Amendment is not self-executing. In Berghaus versus Tompkins, the court reinforced this. A suspect who stayed silent for nearly 3 hours had not invoked his right. He eventually answered questions, and those answers were used against him. What that means for you in that passenger seat, silence alone, will not protect you. What will protect you is saying these exact words out loud. "I'm invoking my Fifth Amendment right to remain silent. I won't be answering any questions." That phrase, spoken on body cam, creates a legal record. Any continued questioning after that point becomes constitutionally problematic for any prosecution. Say it calmly. Say it clearly. "I'm invoking my Fifth Amendment right to remain silent. I won't be answering any questions." Again, "I'm invoking my Fifth Amendment right to remain silent. I won't be answering any questions." Flat tone, neutral, respectful, not defiant. A legal statement, not a confrontation. The bottom line? Silence without the words is legally invisible. The words make it legally real. Cooperation does not mean conversation. The Fifth Amendment protects your words, but the officer still wants your ID card and whether you're legally required to produce a physical ID is governed by completely different case law. Salinas protects your statements. The next phrase protects your wallet. Phrase number 2, I'm a passenger. I'm not legally required to show ID. The mistake is handing over your ID the moment the officer asks, without understanding what the law actually requires. Passengers across this country produce identification every day in situations where no law obligates them to. The scenario: you've invoked your Fifth Amendment right. The officer nods and says, "Okay, but I still need your ID for my report. Standard procedure for everyone in the vehicle. Just hand it over." Standard procedure. For everyone. Designed to make refusal feel unreasonable. Body cam is recording. Here is what the law actually says. The Supreme Court addressed identification demands in Hebel versus 6th Judicial District of Nevada, decided in 2004. The court upheld state stop and identify laws, but with a crucial limitation. Those laws only apply when there is individualized, articulable, reasonable suspicion directed specifically at the person being asked, not at the driver, not at the vehicle, at you, the passenger, personally. A federal appellate court applied this principle directly, ruling that a demand for a passenger's identification is not part of the mission of a traffic stop. Think about what that means. The stop exists because of a traffic violation, a broken taillight, expired tags. That violation belongs to the driver. Unless the officer has independent suspicion that you, the passenger, have committed a crime, demanding your ID exceeds the legal scope of the stop. The correct response, calm and clear: I'm a passenger. I'm not legally required to show ID. Again, if they push, I'm a passenger. I'm not legally required to show ID. One more time. I understand you're asking, but I'm a passenger and I'm not legally required to show ID. Know your state. Roughly 26 states have stop and identify statutes, but even those require individualized reasonable suspicion. California, New York, and Illinois have no such statute. In those states, an officer can ask, but cannot legally compel. Florida and Nevada have statutes, but the same suspicion threshold applies. The bottom line: the officer can ask. The law doesn't always require you to answer. You've protected your words and declined to produce ID. But here is what the officer may do next. He may not let you leave. He steps back and waits, creating the impression that you're stuck. Most passengers assume they must stay. They may be wrong. Understanding your actual legal status gives you the next phrase. Phrase number 3, am I being detained or am I free to go? The mistake is assuming you must remain simply because an officer is present. Passengers comply with prolonged stops, answer questions, consent to searches, all because they believed they had no choice, when legally they may have had one. Here is the constitutional foundation. In Brendlin versus California, decided unanimously in 2007, Justice Souter wrote that when a vehicle is stopped, a passenger is seized for Fourth Amendment purposes, just as the driver is. You are constitutionally seized from the moment that car pulls over. That seizure must be legally reasonable, and that seizure gives you standing to challenge the constitutionality of the entire stop. In Brendlin, the passenger successfully suppressed evidence because the initial stop was unlawful, and he had standing specifically because passengers are seized under the Fourth Amendment, not mere bystanders. Under Rodriguez versus United States, officers cannot extend a stop beyond the time necessary for the original violation without independent reasonable suspicion. That protection applies to your continued detention as a passenger. When you ask, am I being detained or am I free to go? You force the officer to articulate his legal basis on camera. His response, whatever it is, becomes part of the legal record. If he says you are free to go, calmly exit. No sudden movements, hands visible. If he says detained, follow up. On what reasonable suspicion am I being detained? Whatever he says next may be the foundation of a suppression motion. Realistic dialogue. Officer says, just hang tight, we're running some checks. You respond, I want to be respectful, officer. Am I being detained or am I free to go? Pause. Let him answer. Do not fill the silence. That answer is now on body cam. The bottom line, asking about your detention status is not obstruction. It is a constitutional question every seized person has the right to ask. You've invoked the fifth, declined to produce ID, and established your detention status on camera. Here is where passengers make one final critical error. Even after getting this far, they stay silent when the officer asks about their belongings, and that silence can legally function as consent to a search. Phrase number 4, I do not consent to any searches of my person or my belongings. The mistake is staying quiet when the officer says, do you mind if I check your bag? That word check sounds casual. Legally, it is a consent search request. And your silence, your shrug, your passive gesture can be interpreted as agreement on body cam footage a judge will later review. Here is the legal foundation. In Schneckloth v. Bustamante, the Supreme Court ruled that consent searches are constitutionally valid when consent is voluntary, and then held that police are not required to tell you that you have the right to refuse. Officers do not have to tell you that you can say no. If you consent while uninformed, that consent is still legally valid. The legal system will not protect you from ignorance you could have cured by speaking 4 words. Body cam footage here is decisive. A passenger who shrugs while an officer reaches into their bag, that footage looks like voluntary consent. A passenger who says, I do not consent to any searches of my person or my belongings, has created a record requiring independent legal justification for any search that follows. If the officer searches anyway after your clear refusal, that is a Fourth Amendment violation and evidence found may be suppressed. I do not consent to any searches of my person or my belongings. If pressed, I do not consent to any searches. Once more, I do not consent to any searches of my person or my belongings. The bottom line, only your explicit refusal protects your Fourth Amendment rights, because the law doesn't require officers to remind you that you can say no. Your consent refusal protects your property. But there is a fifth pressure point that arrives early in the encounter, the most legally aggressive thing an officer can do to a passenger. And it requires a phrase that reframes the entire legal encounter on camera. Phrase number 5. Are you ordering me to identify myself? Because what is your reasonable suspicion that I've committed a crime? The mistake is failing to distinguish between a request and a lawful order. Officers are trained to phrase requests as commands. I need your ID sounds like an order. It may not be a lawful one. Terry v. Ohio established that officers may detain a person based on specific, articulable facts of criminal activity directed at that individual. Brown v. Texas, decided in 1979, ruled unanimously that demanding identification without individualized reasonable suspicion violates the Fourth Amendment. Being present in a stopped vehicle by itself is not reasonable suspicion directed at a passenger. High crime area, nervous appearance, proximity to a driver, none of these alone are constitutionally sufficient under Brown. So when you ask, are you ordering me to identify myself? Because what is your reasonable suspicion that I've committed a crime? You force the officer to commit on camera. If he says yes, I'm ordering you. He has asserted individualized reasonable suspicion. Ask what it is. Whatever he says next is documented and may support a future suppression motion. If he cannot articulate specific facts about your conduct, that order may be unlawful under Brown v. Texas. Dialogue. Officer says, I need to see your ID before you go anywhere. You. Officer, are you ordering me to identify myself? Because what is your reasonable suspicion that I've committed a crime? Pause. Let him answer. Stay calm. If he gives a lawful order and articulates specific suspicion, comply. But say, I'll comply, but I'm doing so under protest and my hands will stay visible. That sentence preserves your right to challenge the detention without escalating the encounter. The bottom line, every ID demand from a passenger must be backed by individualized reasonable suspicion, and asking for it on camera is constitutionally protected inquiry, not obstruction. Before your closing recap, 2 things you must understand: what officers are legally allowed to say, and how to handle the request versus order distinction. Police can legally lie to you. Officers can tell you they have evidence they don't have. They can tell you the driver already consented. They can say cooperation will make this easier, a phrase designed to make refusal feel like a legal problem. Verbal deception is legally permissible during investigations. This is exactly why the 5 phrases matter. They assert your rights regardless of what the officer tells you. When an officer gives you a directive, ask, Officer, are you asking me or ordering me to do that? If asking, you can decline politely and legally. If ordering, you must comply. But say first, what is the lawful reason for this order? That question, on camera, creates a legal record. While complying, I'm complying under protest. My hands will remain visible. Your body cam matters too. Say, for everyone's safety, I'm recording this interaction as well. Hold your phone in plain sight between the officer's body cam and yours. Every word is preserved. A passenger who stayed calm, spoke clearly, invoked rights by name, and asked lawful questions on camera is a passenger whose attorney has something real to work with. Stay calm, stay polite, but stay firm. Be respectful, not talkative. Your tone matters as much as your words. Here is the single most important principle. Your rights as a passenger are real, backed by Supreme Court precedent, and only protected if you actually use them. Out loud, clearly, on camera. Lock in the 4 phrases every person in every vehicle needs to have memorized before they ever need them. The first phrase, when any questioning begins, am I free to leave? Establish your legal status immediately. From Brendlin versus California, you know you are seized as a passenger. Find out if you're free to end that seizure. The second phrase, when questioned about anything, I invoke my right to remain silent. From Salinas versus Texas, silence alone is not protection. You must say the words, I invoke my right to remain silent. That is the only invocation the law recognizes. The third phrase, if the encounter escalates, I want an attorney. You can invoke your right to counsel before arrest. You do not have to wait for handcuffs. I want an attorney ends lawful interrogation immediately. The fourth phrase, anytime a search is suggested, I do not consent to any searches. Of your person, of your bag, of anything connected to you. Clear, unambiguous, on camera. I do not consent to any searches. Your practical next step, write these 4 phrases down right now. Put them in your phone. Practice saying them out loud until they come automatically and calmly. Because in a real traffic stop, the only phrases that protect you are the ones you've already rehearsed. Remember, this is educational content only, not legal advice. Laws vary significantly by state. Always consult a qualified attorney in your jurisdiction for your specific situation. Now you know all 5 phrases and the case law behind each one. Why silence without explicit invocation fails under Salinas. Why being a passenger does not automatically require ID under Hebel. Why you can challenge your detention under Brendlin. why refusal to consent must be spoken under Schneckloth, and why an ID demand without individualized reasonable suspicion may be constitutionally invalid under Terry and Brown. There is deeper case law analysis that builds on what you just learned. Constitutional protections that apply in situations beyond the basic stop. I break those down in the next video. It is on screen right now. Watch it to complete your legal education. Let me know in the comments where you're watching from and what time it is right now. Stay protected. Know your rights.